Well, thanks again for being with us today. We really
Thank you.
appreciate it. Some of you may or may not know that part of the EEOC's role, yes, they are the hammer, they are the enforcement entity, but they also educate the community and educate employers about Title VII and some of the things that employers could do to minimize incidents of sexual harassment and all kinds of discriminatory conduct in the workplace. So he's here in his role as educator along with his colleague Terry. What's the Office of Outreach? Is there an official name?
Outreach and training.
Outreach and training. And so they make training opportunities available to employers, so definitely take advantage of it. We definitely, even as management side lawyers, we want to work in partnership with the EEOC to make sure our clients are well protected, and if something does happen, then we know that we can partner with the EEOC to try to find resolutions. So, that's it.
Thank you.
Without everything in the media about Me Too and sexual harassment claims, have you seen any spike in claims?
No, I think what we've noticed for over the years is that number's pretty much remained static. The majority of the cases, depending on where you are, but here in Georgia, I've been here about 3.5 years, and I looked at the statistics. It's pretty straightforward. We have the majority of the claims that are raised. The second category would be the sex discrimination. That's roughly about a third of the charge that we receive. About 1,600 roughly, 1,600 per year. Now trying to segregate out those sex discrimination claims into whether or not they're sex-based discrimination versus sexual harassment, that's kind of difficult, but I would still hazard a guess. Anecdotally, the majority of the cases that we do receive through the door related to sex-based discrimination relate to sexual harassment.
Do you expect anything? You think you expect an uptick in the future?
Well, I always said an informed public is a public that generally will go to either us or FIPA. So I think, again, anecdotally, I haven't seen an uptick yet. I've talked to the enforcement managers and some of the supervisors as well as CRT, youth supervisor. We haven't really seen an uptick, but you do have individuals that are calling, inquiring about what's going on. And I think one of the earlier panel members talked about how the big umbrella of Me Too, what that constitutes. But we're generally dealing with just the employment arena. And in the employment setting, the numbers as far as uptick, severe uptick, or drastic uptick, I don't anticipate that because we, again, going back over just a period of time, it's really been essentially about a third of the charges that we receive nationwide. And also that's reflected in the data here in Atlanta as well, the Atlanta district.
Do the sexual harassment claims that you see today look any different than 10 years ago?
There's a coarsening of society, I will say that, and
A what?
a coarsening of society. So as a result of that, the manifestation of it is a little different. I think you also have individuals that are baby boomers as they retire, millennials, Generation X. You do see a lot of millennials now in the workplace, and some of their conduct can be characterized as crude. But I think generally speaking, just look at the dynamics between coworkers. It's the same stuff. You have to bantering about, and depending on what the industry is. But it's the same stuff that you've always seen over the years. But again, it's a little bit more coarser in a sense of the description of it. And those are the charges that you rarely see that are public because employers have an incentive to deal with us earlier in a sense of trying to at least get an early settlement, or there's a private settlement that we will actually look at and we'll adopt that. Or there's also the aspect of mediation that we have. So just generally speaking, the conduct in and of itself, no. But there has been a coarsening of society in the sense that some of the allegations that you may see in charges now are pretty straightforward. Same thing, you could just analogize that to like songs. Back in the day, listen to the Isley Brothers versus what you hear now. Yeah.
I mean, my guess would be that there would be more same-sex harassment claims or even claims by, as Carmen talked about, sort of third parties who are witnessing harassment. Is that true?
But taking the former, I think that's actually a good thing though. I think as a society, again, the moral arc of the universe spins towards justice. Justice has different permutations. And I think LGBT members were more reluctant in the past to come forward and assert their rights, to vindicate those civil rights, especially in the employment arena. So there has been a material, measurable increase in those particular charges that we do receive. Now again, it's the chicken or the egg. Is it happening more or just people reporting it more? But I think still the actual outcome of that is still good though. You have LGBT members that are actually reporting that. So in that sense, that's a very positive thing. But it's the same type of conduct that you see. Generally, you got the conduct, you got the verbalization of things like that. So verbal and physical conduct. So that's actually a very good thing.
How about with the way people are using the internet and social media?
Wow.
And I know I hadn't asked you this before, but
No,
it
it's
just
fine.
occurred to me that harassment may take different forms with.
It does, and I was very interested in listening to the last panel member talking about on the phone, Tinder. There was a question asked about Tinder. But I was also saying, well, I'm hoping that person's not on their employer-issued phone, even though they're outside of the job talking about grabbing whatever they were doing there. But yeah, but I think that just opened up another avenue. I don't really think the conduct has changed. It's, again, you can say that's a coarsening of society. I don't really know if I would take that position, but you do see a lot of more social media and social media allegations now, because some of the charges we receive as attachments, now you have text messages. You even have pictures, believe it or not. And the pictures can be quite explicit with the requests that are associated with, look at this, come get this, and things like that.
They're being attached to the charges?
Yes, yes. So that presents an issue for us. But again, we get desensitized to it, just like she was talking earlier, though. It is what we do on a daily basis. So it can be, to some people's ears, like very coarse, but we deal with it on a day-to-day basis. But again, you see charges now related to social media and some of the allegations related to sexual harassment, and it's very explicit in some of the information that we receive, which does assist with the investigation, though, I will say that. Yeah. It can assist, oftentimes.
Now, how about claims that, I call them third-party bystanders, so where the firm client, for example, is coming on to the associate, or the UPS delivery person who can't help but brush up against a breast when he's in the office visiting the receptionist or dropping off a package. Are you seeing any of those types of claims by an employee who's complaining that he or she is not adequately protected by the employer
Yes.
against this?
Yeah, and that goes back to the new or should have known standard, just the negligence standard. What information did the employer have as far as notice, and what measures did they take to at least promptly and immediately address the discrimination, even though it's not from a coworker or a superior, it's dealing with a third party. So we do see those, and that's remained a smaller percentage of what we see, but though they're frequent enough where that's just a regular routine part of the investigation that the investigators conduct there, or the administrative judges sometimes will have cases where you have the federal agencies and you have vendors coming in, and you see a very few of those as well. But we do see those third-party harassment type claims, and that's just not something that it's common enough, but we see those frequently enough where it's not novel for us to investigate those and reach some type of conclusions.
Tell me this, is there a hierarchy of sexual harassment claims? Is the EEOC more interested in claims that involve, I don't know, power dynamics, so supervisor, subordinate, or even same sex? Are there any particularly sexy claims for the EEOC, if I can say it that way?
Sex is always sexy. What I will say no, because what we look at, as I always try to convey and impart to the staff, is that each person's case is unique, but that person should receive the same amount of attention as someone else. Now, we do have strategic enforcement plan priorities, and harassment is one of those when we start looking at class of systemic allegations. But generally, no. I mean, we don't look at anything being more sexier than others. Of course, context is always key. But what we try to do is just make sure that we look at the charge, we look at a response from the respondent, conduct an adequate enough investigation so we can make a determination if reasonable cause exists to actually have a finding. But we don't prioritize any claims that are more sexier than others. Although it does sound, for maybe some people with prurient interest, it could result in some investigators taking a little bit extra, going to like maybe an adult club. We get, Atlanta's known for their strip clubs. So we do have an amount of charges that we receive from some of the adult entertainers there. So that's kind of sexy. Could be prurient, but we do. And the issue generally there is an independent contractor, or are you an employee? But we have to really flush out using the test and things like that. But that could result in an on-site or two from.
But what are the Title VII claims in those situations?
Sex harassment.
We get them from the customers or from the?
From the adult entertainers, the dancers. Their terms and conditions of employment may be a little different from other dancers because of favoritism, because of maybe possibly the owner. But again, if you sign a contract, you're an independent contractor. But you can ask the question, well, is it knowingly, intelligently, voluntarily entered into? Or was there duress when you signed this? Or you look at who's controlling the terms and conditions of your employment, when you could go on stage. What type of music are you going to actually get? What time do you go on there? So there are a lot of real substantive issues that you address, and they get very minute. But at the end of the day, though, we do, because Atlanta's, the clubs here, we do get a number of charges dealing with those types of issues. But sexual harassment, straight Title VII.
Now, so it sounds like the EEOC is doing that work of peeling back the layers of the onion to determine whether somebody who on paper is a 1099 independent contractor, but who could be an employee.
Correct. Because there are other things that I've learned in my experience that are associated with some of those charges, is that certain rooms that people go in and may make some money that way, or how much money they get on reserve as far as selling drinks to the customers and things like that. What percentage do you get versus someone else? At the end of the day, it's a cost-benefit analysis for the club owner, but for a person out there trying to take care of her family, it's like, okay, why is she making more money than I'm making if we're doing the same thing, and you're giving her a certain percentage and I'm not getting a certain percentage? So it gets kind of tricky, it gets kind of ugly, but that's what we do at the EEOC. Yeah.
Now, I know you said there's no hierarchy of claims, but you investigate some charges, you don't others, right? What makes the difference?
Well, we have, it's called Priority Charge Handling Processes Procedures. As everyone knows, the EEOC is a very small agency, and we have roughly about 2,000 employees nationwide. So we're a small agency, but we have to get the most bang for the buck. And in Atlanta, the Atlanta district comprises a whole state of Georgia and 12 counties in South Carolina. We receive approximately 5,000 to 6,000 charges a year. So we have to prioritize the work that we're going to do. And sometimes when someone comes through the door, we have to go through the process of looking at those charges and assessing them and making the determination whether or not we're going to invest the resources into investigating them. Fortunately for the public, though, that's just one aspect, because we're just dealing with the administrative aspect of this. But you do have a final resort if you want to go to federal court. And in those situations, we may issue a notice of right to sue, dismissal, and notice of right to sue, so that person can go to a court of competent jurisdiction and prosecute their claims under Title VII that way.
Okay. So would claims, you mentioned the EEOC priorities before,
Yes.
and sort of class-based claims, maybe serial offenders, if that's
Yes.
the right word to use?
Yes.
Are those kinds of charges more likely to get
They will receive
investigated?
more than like, well, not more than like, they will receive more attention, because we try to at least initially look at who the respondent is. We look at the charging party making the allegations. Who is the respondent? We look to see if who's the responsible management official, if he or she is a serial harasser. We have certain things that we can look at to see if that name has really popped up before. So we'll look at that to ascertain whether or not we should give a little bit more scrutiny to that particular case, in a sense of just really looking at a repeat offender or a repeat respondent who has not taken remedial measures to at least ameliorate the conditions or adequate training. So there are things that we do. For instance, we may have a respondent where we've entered into an agreement where you're going to provide annual training to your staff. If we're looking at 2 years in, we're still receiving a fair amount of charges related to that respondent, and we have to really ask ourselves, okay, what are you really doing to at least address the sexual harassment acts of the claim that we receive? And so we may go in and take another look to see, okay, what's really going on here, and we may have to be a little bit stronger in enforcement.
Are you dealing with claims at all about, from people who claim that they have been wrongfully accused of sexual harassment, that there was some kind of discriminatory basis for them being accused, or any form of a false claim, as I call them?
Well, we like to stay away from false claims, because we think everything is meritorious because that person may believe it. You never know what you're really dealing with. But yeah, we get a fair amount of individuals saying that I've been falsely accused by her. It's generally a male being falsely accused. I've been falsely accused by her or others. And we actually have situations, well, we've had situations where you had, for the lack of a better word, trumped up charges against an individual. But it takes a very thorough investigation to really reach that conclusion. But it's not as high a percentage as you had. Generally, the individuals like that are arguing on the margins. Well, yeah, I used to see her, but we stopped a long time ago. And so now she's accusing me of something, and maybe in a temporal sense, she's off by a month or two, and I really stopped calling her, texting her. So she's lying about me doing X, Y, and Z. Those are the types of real things that we see. But generally speaking, just the straight-up false claims, they don't constitute a large enough percentage of our cases to really be in a sense, material to really just say, reach any conclusions about it. But it happens, but it's so infrequent, but it happens enough where we're just trying to make sure that, again, that person's not coming in for the 7th time, making the same allegations against different people. And it's a profit motive for some individuals as well. And they go to different jobs, they file EEOC complaints alleging certain things related to sexual harassment, and they may have succeeded before, different jurisdictions. And they come to Atlanta, and they don't think that we're going to find that out, but there are ways we can determine whether or not a person's a serial filer and alleging discrimination against her immediate supervisor in the same generally sense that they've done alleged in other parts of the country.
Can I say amen?
A-
Because
sing it, sister. Go
this
ahead.
is
Go
what
ahead. Amen.
this is what the profit motive. The profit
Yes.
motive is there. It's a real thing
It is.
for us, and I'm glad to hear that the EEOC is ferreting out some of that stuff.
We try to, but remember, we're human as well. And if a person is doing a good job of concealing those types of issues, it's going to be hard. But again, we have a very competent staff. I would say that at least if the investigator is paying enough attention to some of the allegations, and I think that's also where it comes into partnership with maybe the private bar, is that if you know of or you suspect you have allegations like that, feel free to at least apprise us of that information so we can use that in some of the investigative tools that we have. We can determine whether or not these allegations are false, because there is a profit motive for some people to line their pockets with unclean money, I'll say. Yeah.
We are running short on time, but I do want to ask you about something that we talked about before, and that is the way employers investigate sexual harassment claims and why investigations are so important. And you said prompt doesn't mean thorough. Right. So what kinds of mistakes do you find employers make in investigating sexual harassment claims?
I think the objectivity gets lost initially, and I think that sometimes I call it the garbage in, garbage out approach. And I know it's difficult because it's dealing with sex, but you really have to just take a real step back and just be very thorough in a sense of like, okay, we don't need brevity in these situations. We don't need promptness. We just make sure that you've taken reasonable measures to address the harassment. I think oftentimes people conflate timeliness with just quick. Time is just, it could be over a period of time that you're actually investigating. As long as the interim steps that you've taken to at least maybe take the harasser, the alleged victim, take them out of maybe the supervisory chain, or take them out of the different departments, maybe even give someone some leave if you can, change the shifts and things like that. But just telling me that someone's complained on a Monday and you've completed an investigation on Wednesday or Thursday, when a person say that you haven't even talked to my girlfriend or my coworker or my boyfriend or whomever, because they may have contemporaneous information that I actually talked to them about related to these allegations. So when it comes over to the EEOC and we're trying to start blank slates, tabula rasa, let's look at what we have here, and we're like, okay, you missed these steps, you missed these steps. So at some point you say, if you missed these preliminary steps, in our opinion, what would have made a prudent, thorough investigation? So what else did you miss? So now we have to conduct an on-site or fact-finding conference. And so it's almost like the report that you've given us. It's good to look at, but it has so many holes in it that you can look at it and say, we're going to have to just start from scratch. So I would just caution and encourage all employers to at least be very objective. Don't be so concerned with time in the sense of getting something memorialized with your findings. Just take the interim steps necessary to at least address immediately, in a temporary sense, the allegations and see what you can do. But after that, take your time in memorializing what you need to memorialize, because we're going to look at that, and I hate to say it, with a very discriminating eye, and we're not Monday morning quarterback, and we're just trying to say what was prudent under the circumstances that should have been done as far as conducting an investigation.
Got it. Well, we hope you'll stay around for some questions.
Sure.
Okay, but we're going to move to Chandra.
Okay, thank you.
Yeah, thank you.
Okay.